This new entry matters. What changed the February 11th, 2026 amended complaint 30s now names David Archbell, Robert Thayer, Chad I. Gray, John J. Fyan, Jeanine S. Hogg, Jeff Swoboda, City of Fort Collins, Board of County Commissioners for the County of Larimer. Notably removed from the earlier amended list you provided, David A. Rod, duplicative I, double listings. Larimer County as a separately named entity, now replaced with the Board of County Commissioners. That cleanup suggests either 1. The court ordered him to correct structural defects, or 2. He realized some of the prior naming errors. 1. Board of County Commissioners versus Larimer County. Naming the Board of County Commissioners is the proper way to sue a Colorado County entity that's procedurally cleaner than just Larimer County. However, this doesn't fix the real problem. To hold the board liable under Title 1983, he must allege a constitutional violation caused by an official policy, custom, or practice adopted or ratified by the board. That's a Monell standard. It's demanding. Most pro se complaints fail here. Number 2, City of Fort Collins, same issue. He must show a constitutional deprivation caused by a municipal policy or long-standing custom. Not just that police or officials interacted with him. If his allegations are about code enforcement, service disputes, personal conflicts, YouTube commentary, that won't meet municipal liability standards unless he ties it to formal policy. Number 3, individual officials, Gray, Fyan, Hogg, Swoboda. If sued in individual capacity, he must show personal participation, under color of state law, violation of a clearly established constitutional right. They will likely assert qualified immunity. Unless there is a very clear constitutional violation, that's a major hurdle. Number 4, private individuals, Archbell, Thayer. This is still a structural weakness. Private citizens are not liable under 1983 unless they were willful participants in joint action with the state, or there was a conspiracy with state actors that requires factual allegations, not conclusions. Courts dismiss conspiracy claims that lack specific facts. If his theory is, YouTubers criticized him, officials didn't act the way he wanted, therefore they're all conspiring, that won't survive a motion to dismiss. Number 5, procedural timing matters. This is now amended complaint number 2, effectively. Key questions. Has he properly served all defendants? Is the court still in screening stage? Has the judge warned about deficiencies before? If the court already required him to cure defects and he continues filing shifting complaints, the judge can dismiss for failure to comply, dismiss for failure to state a claim, potentially restrict future filings if it becomes abusive. Federal judges have limited patience with serial, evolving pro se pleadings. 6. What this filing suggests removing A-Rod is significant. That tells me he may have realized the blocking service argument was legally untenable, or the court flagged the issue. It does not fix the deeper issues: lack of state action for private defendants, lack of policy allegations for municipalities, qualified immunity barriers, repackaging previously dismissed theories. Bottom line, this amendment looks like procedural reshuffling, not a substantive strengthening of the case. Unless this complaint contains specific constitutional violations, specific acts by each defendant, clear policy custom allegations, proper service of law, it's still highly vulnerable to dismissal under Rule 12b-6. If you want, I can walk through how a judge in the District of Colorado will analyze this at the motion to dismiss stage, step by step, including how each category of defendant is likely to be treated.